Hey guys. So in today's What in the we are going to be looking at Emani Ellis's motion for a new trial and a motion from Cardi B's team in relation to an order to show cause that was filed against the attorneys for Emani Ellis. Um, Seems like the attorney might be evading service, but we're going to read it. We're going to get all the details. We're going to see exactly what's going on. So, we've got motions. We have motions. We're going to start off with what I think is the bigger news. We have Emani Ellis motioning for a new trial. It's 9 pages. We're going to get through it pretty quickly. We're also going to take a look at there's been some order to show cause drama going on back and forth relating to Ron Rosen Janfaza, so Emani Ellis's attorneys, trial misconduct. So we're going to get to all of it. We're going to get to all of it. I see early we have ML Loving Life says ridiculous. The show goes on. The show goes on, and we will be talking about the pen throwing. Lots of stuff in the news about things being thrown. We have the sandwich throwing trial. The jury is they're done deliberating for the day. They deliberated just over 2 hours today. So if you've been following that, that's the Sean Dunn trial in DC. We'll get together for a recap tomorrow and hopefully maybe a verdict. They've been deliberating for more than 2 hours over there. Courtney Clenny, the OnlyFans model, says she flung through a knife and didn't intend to, but did kill her boyfriend, Christian Obumseli. She had a hearing this morning scheduled, but it was continued to the 5th of December. We've also got 3 cases we're going to look at. One, there hasn't been an arrest yet. Another, I think there's been an arrest, and another a conviction involving fast food and people just raging out in fast food establishments. So that's what we've got on the docket for what in the is coming up over the next few days. But today it's all about this Cardi B story. We've got a motion for a new trial. So this intent was filed, and there was supposed to be a hearing for it today. And we have the actual motion here. So let's see what the arguments for a new trial by Emani Ellis's team are. So let's see. Please take notice that pursuant to Code of Civil Procedure 657, Plaintiff Emani Ellis will move the court to grant a new trial in the above referenced matter. This motion for new trial will be heard on December 5th, 2025 at 10 a.m. So there's going to be a Courtney Clenny hearing and this hearing for this motion for a new trial. So there we go. Let's see. This motion is made based upon this motion, the declaration of Ron A. Rosen Janfaza, the memorandum of points and authorities, the pleadings, documents, records, and the files in this action. Documentary and video evidence as may be presented at the hearings, as well as any witnesses who will testify. This motion for a new trial will be made upon the following grounds pursuant to Code of Civil Procedure 657. So one, they're choosing 4 of the possible available grounds. There are several others that are available to them, but these are the 4 that they're going to argue here. So one is irregularity in the proceedings of the court, jury, or adverse party, or any order of the court or abuse of discretion by which either party was prevented from having a fair trial under Code of Civil Procedure 657(1). 2, accident or surprise, which ordinary prudence could not have guarded against. Insufficiency of the evidence to justify the verdict or other decision, or the verdict or the other decision is against the law, Code of Civil Procedure. And then 4, error in law occurring at the trial and accepted to by the party making the application. So let's see. They filed this notice of intent, and then here's their memorandum of points and authorities to support their request. So, Plaintiff Emani Ellis was assaulted and battered by defendant Belcalis Marlenis Almanazar on February 24th, 2018. The parties proceeded to trial before a jury of 12 people, which lasted from August 25th, 2025 to September 2nd, 2025. Defendant obtained a defense verdict. Plaintiff's counsel, and remember, after that all happened, Cardi B was speaking to the press outside, and she was asked, some reporter asked her if she planned on like any countersuit And she turned it into a moment like warning others, but said that was not her intent to do in relation to this specific case, in relation to Emani Ellis. So there was no countersuit at trial. There was no plan mentioned by Cardi B of a countersuit after the fact. This verdict was just one direction, not in the favor of the plaintiff. Cardi B was found not liable. So let's see here. The multiple reasons. First, there was trial misconduct by defense counsel Peter Anderson, who should be held in contempt for his violations of court orders and the California Rules of Professional Responsibility. Defense counsel violated California Rules of Professional Responsibility, Rule 3.1, 310, threatening criminal, administrative, or disciplinary charges. Defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the course of the trial, that he would report him to the State Bar of California. Defense counsel violated California Rules of Professional Responsibility, Rule 310. The granting of a new trial is appropriate because the record establishes that defense counsel threatened plaintiff's counsel to obtain an advantage in a civil matter both before and during the trial, lastly on August 27, 2025, in the Alhambra courthouse. Second, defense counsel Peter Anderson also physically intervened when plaintiff's counsel was speaking with Dr. Finke on August 27, 2025, at the Alhambra courthouse, which amounted to an assault and battery. So, I don't know. Did Dr. Fink press charges here? So I don't know. I haven't read this yet. That kind of just stumped me reading that. Because I guess I assumed that we were going to hear about the pen. But now we're also alleging that opposing counsel assaulted a witness. So is there do we have an affidavit from Dr. Fink here? Or are we just speaking on his behalf and drawing a conclusion here? But anyway, unfortunately, the jury was present in the hallway waiting to enter the courtroom during this interaction. So you want the jury to be present to witness it, because then you'd have a better, to me, this concedes. If you're saying, unfortunately, the jury didn't witness this, then it didn't impact the jury. You're conceding that it didn't have an impact on the confidence of the verdict. This is not the only time that defense counsel has unlawfully made contact with plaintiff's counsel against his wishes. I think we might hear more about this in the follow-up from Cardi's team about their attempts to effectuate service upon the attorney writing this motion. So, can't wait for that. Third, to add insult to injury, on September 2nd, 2025, defendant threw a pen at a man outside the Alhambra courthouse in California. So I think everyone's familiar with that viral moment. She was questioned about if there were going to be paternity issues with her rumored pregnancy, which is now not so much a rumor. And she threw a pen. Again, we're all aware that happened. The court was put on notice. Not sure if there's any action being pursued by that reporter, that journalist. The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. So is this referring to somebody that isn't the reporter? And let's see if we have an affidavit from this person. It was also completely unlawful and disrespectful for defendant to injure others during the trial, others plural, during the trial on the Alhambra courthouse property, which she did on September 2nd, 2025. Additional time is needed to determine if defendant's actions of throwing a pen at a man outside the Alhambra courthouse were witnessed by the jury. To be honest, we're in November now, and this is the party bringing this motion forward. They should have had time, unless they're requesting some type of permission from the court where they need the court to order somebody to sit and speak and do some fact finding. Why are you asking for time to do this now? Plaintiff requests additional time to investigate this further. Jurors would be intimidated if they had viewed this type of conduct. And again, you're conceding that the jury wasn't impacted by this. I mean, maybe you could imply they saw it on social media or something, but that would be going against the judge's orders. The implication would be that the jury or one of the members of the jury was being dishonest when the judge does their usual spiel, like, hey, have you looked at anything? So this again to me is a concession that you're not even arguing, you're not able to argue that it had an impact on the jury's verdict. And honestly, if the jury saw it, wouldn't they be more inclined to convict? I mean, to find liable? Hold on, pause. Let's pause on that. If the jury had seen Cardi B throwing object at somebody outside right before they're about to deliberate, would that not make somebody go, maybe this is what she does? Maybe when she's confronted, she takes it too far and the hand is going. So it might have been beneficial for your client if the jury had seen that. Anyway, this is not defendant's first time injuring others. In July 2023, defendant she metaphorically threw a microphone at a concert goer at Dre's Beach Club in Las Vegas, Nevada, who was injured. I believe that litigation is still ongoing. I could be wrong. Defendant clearly feels she is above the law and can do whatever she wishes to do. But that's a civil action, right? So, I mean, that's still ongoing. So I don't think the determination in the civil realm for this Las Vegas incident is determined. I think that's still in progress. But as far as law enforcement choosing to do anything about the Las Vegas incident or going back to the incident at hand here at the medical facility, and in the criminal realm, it seems like nobody found cause to pursue criminal charges. So this just seems like a throw-in statement that sounds tough, but what is it backed by? Because this hasn't concluded yet. So you can't say that Cardi feels she's above the law when we haven't really heard Cardi in court say, like, argue against it or say that it was justified. Plaintiff should be allowed a fair trial before a jury of 12 people. Granting plaintiff a new trial would provide her with the closure that she needs. This isn't why we grant trials. We don't grant new trials, because somebody needs closure. This is the closure, and you're not respecting it. I didn't expect to be on this wavelength reading this, you guys. I really didn't. But here we go. Let's get into argument 2. Let's see what you guys are saying. Laundered Amber's in the bushes. Amisha's like, she should take that out. This is looking like a waste of money. I don't think this is an effective argument so far. This seems like, please just give us a new trial because we don't want to be the losers. And that's not a good argument for a new trial. But we'll see. There's still some more. There's still some more arguments to go through. Yeah, Curious Lay, I don't think you're the only person in the chat with this sentiment, so it's outside of my realm. But Curious Lay and others are pointing out that, only one of these lawyers has a violent history. And if that's the case, I would say that this falls even more flat, or what are we doing? Shout out to J Money in the building, asking everyone to please kindly smash that like button. Thank you, guys. Matthew McLellan says she could have used a sandwich at least. See, but that was lunch break. She didn't have time to go get the sandwich yet. So she had to work with what she had available. So Ghost says this motion's insanity. Keith is hanging out watching from Chicago. Shout out to Chicago. Shout out to wherever you guys are tuning in from today. Oh, guys. Okay. Ruthie says Emily D. Baker has done a look at this attorney. It is something wrong with him. You should look into him. I actually, one of the trial days, I watched Emily recap. And I think maybe the attorney wasn't a hot topic, so I missed that. But I love Emily's take, so I'm definitely going to go digging through her Cardi B streams and see what's going on. Because she's from Los Angeles. She's from this area, so very interested to see what Emily D has to say. Shout out to Steph being a member for 11 months, says, yay, Cats Live. It's unplanned. I saw Kathy Roussan post that Emani Ellis wants to file this motion for a new trial. I went and grabbed the documents, and now we're looking at them. They seem messy. So, guys, let's see. Let's see. Miku's headphones. Always good to see you. I feel like I'm barging in the middle of a conversation where I am missing context, but I do see you saying if you want to keep Nisa in our thoughts with positive vibes, 100%. So sorry to miss the context, but sending you the best wishes here. And again, thanks for hanging out with us. We've got this second argument, guys. Let's see if it gets better. Refusal to grant plaintiff's request for judicial notice was an error in law. Defendant testified about the length of her nails in a photograph presented to the jury. Defendant testified that the picture was taken on February 24th, 2018, and that was the 67th National Basketball Association All-Star Game was on February 24th, 2018. February 24th was the date. Was the 24th the date of the incident? That's what they said at the beginning of this motion. So they're saying in this, because I don't remember from the trial the specific dates, but I do remember the theory was the nails weren't pointy. So, but if this was the day of the incident, February 24th, according to what they're stating here, and now they're arguing, well, when they were discussing this NBA All-Star game and showed the picture of the nails for that event, to make a point, they said that it was February 24th, which was untruthful and inaccurate. Plaintiff filed a request for judicial notice that the 67th National Basketball Association All-Star Game took place on February 18th, 2018. And this was the year Fergie did the national anthem. Don't ask me why I remember that. Don't ask me why I remember that. I may have had to search that up to look back at that moment in history. But I guess the point is the date's inaccurate. It could go to the jury's interpretation of the context. So if the judge denied letting this correction go forward or taking judicial notice, because taking judicial notice, when did they file a request for judicial notice? Because what kind of remedy is that anyway? If you're not also requesting like, hey, issue an instruction to the jury, or to stipulate to a correction where both parties can say whatever. Asking the judge, making a request for judicial notice is different than seeking a remedy that would correct the record for the jury to hear. So, but anyway, I would imagine if I was on the juror, I would imagine I take notes of the dates. I would go, well, All-Star Game, same day as the incident, that can't be. She's describing that she got her nails done like the Wednesday before or something to that effect. So we're making a mistake on the date, but the context was still described as a few days before I had this event where I'm promoting my music. I had this style of nails, which aren't pointy and sharp. And my nails typically last me 2 weeks. That's how I remember the context of the testimony outside the specific dates. But the context doesn't change for me personally. So I would imagine the judge was like, what do you need me to take judicial notice for? What does this affect? So, but I don't know. I don't remember this happening, but they're representing it here as just a request for judicial notice. So, let's see. Okay, and Miku's also says it was about a week after the trial that the EDB stream where she talks about the attorney stuff. So thank you, because I would go through the week of the trial. So that's really helpful. Oh man. Chat. Let's get to the third argument. This is a lot, guys. We made it through 4 pages, and that's how much I've yapped. So let's see. 3, the jury verdict was unsupported by the evidence due to the allowance of non-disclosed witnesses. I don't understand this by the caption. So if we're making a sufficiency, because the way this reads, the way that the Code of Civil Procedure 657 reads, there is an or, like this 0.6 Says insufficiency of the evidence to justify the verdict. So there's not enough evidence on the record that a reasonable person, to the preponderance of the evidence standard, could make this decision. Or there's an or here. The verdict or other decision is against the law, right? That's two different things on the sides of that or. But if we look at the caption here in the actual motion, this isn't arguing that there was an error of law. This argument is for the first part, the left side of the or, an insufficiency of the evidence. But you're the plaintiff. So I'm not a lawyer, but in a civil case, if somebody is the plaintiff and there's no counterclaim, right? This would be different if there was, think of the Depp v. Heard trial, where both sides have counterclaims going and there's a verdict that awards something on both sides. There's a finding against each party in relation to each of their respective claims. Well, then it would make sense that even though, Johnny Depp was the plaintiff in the main suit and then the defendant in the countersuit, he could make an argument about a sufficiency of the evidence from the role of a defendant. I never really heard, and I don't know if that's a proper vehicle, where a plaintiff can make a sufficiency of the evidence argument when there is no countersuit, and thus they are the only party bearing a burden to prove to a certain standard. So I'm surprised they're not arguing an error in law here, and they're going with the sufficiency of the evidence. But I'm not a lawyer, and maybe that's just something that's beyond my layperson understanding. So they argue here that it is well established that when ruling on a motion for a new trial, alleging that the evidence at trial was insufficient to support the verdict, the trial court evaluates the evidence as a whole and weighs the evidence sitting as an independent trier of fact. Plaintiff filed in opposition to the introduction of the name of her own doctor, David Fink, in written discovery, who she could have surely produced. Defendant could have also contacted her own doctor's office to obtain the name of his employee, Ms. Tiara Malcolm. Dr. Fink's identity was known to the defendant since she booked a medical appointment with her doctor. The law is clear that a court is empowered to exclude evidence and witnesses not otherwise disclosed in response to appropriate discovery per Code of Civil Procedure 2023. Plaintiff also cites did they just cite the whole year's edition of the Code of Civil Procedure? Like just the whole thing that was issued in 2023? Or is that a chapter? Plaintiff also cites the case of Thorne v. Johnson and Washer as a case on point. Are they referring to they cited that in the moment? Because they're not citing it here. And to me, this seems like it's more of an issue with the judge's discretion, an issue with the judge's ruling, rather than a sufficiency of the evidence argument. But maybe I don't know if I'm not catching what they're putting down here, or if they just are not putting it down in a meaningful way. This honorable court had the power to see. This should be an issue. This really isn't an argument under. This is a judicial discretion issue. This honorable court had the power to exclude these two witnesses. The power means discretion, not required to. So this isn't an error of law, which they're not arguing in the caption, but it is part of this little, two sides, the or thing here. I think this is a mess. You guys. This honorable court had the power to exclude these two witnesses as defendant intentionally hid their identity. Plaintiff was precluded from obtaining their depositions early on to cross-examine them. This could not be done at the time of trial. So to me, this caption should be, they're going to argue that the court erred. This should be an argument that they think the court erred or they abused their discretion. So I don't know. But plaintiff did not personally have the names of Dr. Fink and Ms. Malcolm. Defendant did have the name of her own doctor and could have easily obtained the name of her own doctor's assistant. Didn't Emani Ellis work in the same building? Allowing Dr. Fink and Ms. Malcolm to testify at trial was a significant blow to plaintiff's case. These witnesses should not have been allowed to testify. This is not a sufficiency of the evidence argument. This is the evidence that the defendant presented might have flopped my case. This argument does not match this caption, you guys. This is giving direct threats from the Fulton County motion to revoke Young Thug's probation, and then what follows is not direct threats. Oh, we have a conclusion. We made it, chat. We made it. Guys, I did not intend for this to go this way. We're going to get into the order to show cause stuff. What is this conclusion? All of these actions combined had an effect the outcome of this case. All of these actions combined had an effect the outcome of this case. It must mean on the outcome of this case. Plaintiff is entitled to a new trial under the circumstances. Plaintiff's counsel is limited in his ability to provide additional information at this time, as he is represented by counsel for defense counsel's wrongful conduct. But you're going to file an affidavit in 2 seconds, so is it you can't provide information because you're represented by counsel for defense counsel's wrongful conduct? How does that square? It seems like you're defending yourself against something. And then why isn't the other side able to effectuate service if you also have counsel? I can't wait to read that. But anyway, this does not seem like that's the valid reason why you couldn't go and get information as described up here, where you're requesting you need time. Additional time is needed to determine if defendant's actions of throwing a pen at a man outside the Alhambra courthouse were witnessed by the jury. I don't see how that's the issue you raised about needing more time. I don't see how this goes hand in hand with that. Plaintiff's counsel nevertheless submits this motion for a new trial. Guys, this motion is based on this notice, the memorandum of points and authorities attached here too, the declaration of attorney. Okay, so there's a declaration below. Okay, we're going to get the declaration here. That's going to be a time. All pleadings on file in this action, papers and records on file in this action, and upon such other oral and or documented evidence, which may be properly before this court at the time of hearing or this matter. I also feel like it's a weird place to introduce. Is this the first time they've mentioned did they mention it above? I always think it's kind of weird that they're just saying there's a declaration attached. You know, maybe reference it more explicitly above as part of your argument. But yeah. So it's based on his declaration, the points of authorities, all pleadings on file in this action, papers and records on file in this action, and upon such other oral and or documented evidence, which may be properly before this court at the time of hearing of this matter. So for this reason and the additional reasons set forth herein, it is requested that this honorable court grant plaintiff's request for a new trial. All right, so here's the declaration, chat. The declaration of Ron A. Rosenjanfaza. I, Ron A. Rosenjanfaza, declare as follows. I am an attorney at law duly licensed to practice before all of the courts in the state of California. I am attorney of record for plaintiff Emani Ellis. I have personal knowledge of the facts set forth in this declaration and, if called as a witness, could and would testify competently to such facts under oath. Plaintiff Emani Ellis was assaulted and battered by defendant Belcalis Marlenis Almanzar on February 24th, 2018. The parties proceeded to trial before a jury of 12 people, which lasted from August 25th to September 2nd, 2025. Defendant obtained a defense verdict. I respectfully apply to the court for a new trial for multiple reasons, which affected the outcome of this case. First, there was trial misconduct by defense counsel Peter Anderson, who should be held in contempt for his violations of court orders and the California Rules of Professional Responsibility. Defense counsel violated California Rules of Professional Responsibility Rule 310, threatening criminal, administrative, or disciplinary charges. Defense counsel threatened me several times. Does that really read as reporting someone to the bar falls under this? Let's see. So from the State Bar of Cali, Rule 310, threatening criminal, administrative, or disciplinary charges. A lawyer shall not threaten to present criminal, administrative, or disciplinary charges to obtain an advantage in a civil dispute. So, B, as used in paragraph A of this rule, the term administrative charges means the filing or lodging of a complaint with any governmental organization that may order or recommend the loss or suspension of a license, or may impose or recommend the imposition of a fine, pecuniary sanction, or other sanction of a quasi-criminal nature, but does not include filing charges with an administrative entity required by law as a condition precedent to maintaining a civil action. So there are things where you are mandated. If you are counsel and opposing counsel does something, you're mandated to report certain things. So someone saying, I'm going to report this behavior to the bar, it's an issue if it's specifically a threat to obtain an advantage in a civil dispute. But somebody saying, I'm going to report you to the bar for doing thing that you're not supposed to do, that I'm required to report you to the bar for, would not fall under a violation of this Rule 310. And then C, so we'll read it here. It says, as used in this rule, the term civil dispute means a controversy or potential controversy over the rights and duties of two or more persons under civil law, whether or not an action has been commenced, and includes an administrative proceeding of a quasi-civil nature pending before a federal, state, or local government entity. So anything that could end up being litigation. So let's get back to this declaration, because are we going to establish how this was the threat was the direct intent of the threat was to obtain an advantage? So defense counsel violated 310. Defense counsel threatened me several times during the pendency of this case, as well as the course of the trial, that he would report me to the State Bar of California. You're missing an element. Guys, what is the and? What is the and? He says defense counsel violated California rules of professional responsibility, Rule 310. He's missing this. The threats have to be to obtain an advantage in a civil dispute. It also cannot fall under this bubble. And if he wants to make this argument, he needs to include the whole thing. He needs to include the whole thing. Anyway. The granting of a new trial is appropriate because, and I hate when attorneys make declarations or file affidavits to argue their opinion. An affidavit is supposed to go to facts. You are the witness to certain facts. So you are swearing on an affidavit. You're making a declaration that you have personal knowledge of these things. And because that establishes your facts that you're going to rely on to make your argument, you attach that to your argument vehicle. A declaration, an affidavit, where you attest to your personal knowledge of facts isn't supposed to be your argumentative opinion. This is where you're supposed to be providing the things that support an argument. But this just looks like an argument. So, the granting of a new trial is appropriate because the record establishes that defense counsel threatened me to obtain an advantage in a civil matter. So now we're including the element, but we're concluding that the record establishes it. We're already making the conclusion. In a civil matter, both before and during the trial, lastly on August 27th, 2025, in the Alhambra courthouse. Second, defense counsel Peter Anderson also physically intervened when I was speaking with Dr. Fink on August 27th, 2025, at the Alhambra courthouse, which amounted to an assault and battery. Unfortunately, the jury was present in the hallway waiting to enter the courtroom during this interaction. This is word for word what he included above. And this isn't like the way this is worded is just driving me nuts because the jury was present in the hallway, but you're wording it as if to say the jury was present to see that happen, while also saying that they weren't present to see it happen. But this is not the only time that defense counsel has unlawfully made contact with me against my wishes. You know what you could attach to support this? You could attach an affidavit from Dr. Fink. You could attach some documentation that you filed to have someone, stop making contact with you. But this is what we've got. Yes, Miko's, back to that point, Miko's, he is required to tell on him. There are certain things that you are obligated as an attorney to to let somebody know. I saw it recently with Dustin Poosh and Tyrone Blackburn. Tyrone Blackburn, and I think it was resolved. I think it was a mistake, but it got resolved. But in Tyrone Blackburn's headers for his emails, where he sends his correspondence out through, or his headings for his filings, he was listing that he was licensed in a bar, but the registration wasn't active or it wasn't pulling up. And an attorney has to report if somebody's representing themselves as being a member of a bar that they're not actually a member of. And I think it ended up being resolved with no harm in either direction, but Dustin Poosh had to do it. And he worded it like, I saw it and I have to disclose. So, oh, guys. Julie says I call projection. Oh, man. Let's see. Black Butterfly says I got gifted a membership while watching In the Bushes. Thanks, whoever gifted. Hey, Kat, I still watch, but In the Bushes most time. Good to see you, Black Butterfly. Thanks for popping in and saying thank you. And looking, it must have been Rice Street. So I looked at the starred chats and I see 10 gifted memberships here from Rice Street. He's throwing pens at 10 people, turning you green. Turning you green, you guys. So big thank you, Rice Street. Shout out to Rice Street in the chat. You guys know you can use the rice emoji, show some love. Ba-doom-ts. So Big Rice Street says, I bought a horse, it fell, and it said help. I can't giddy up. Stop it. Miku's is snitching on Rice Street, telling the judge that he threw pens at the chat. Oh, man. Thank you again, Rice Street. Big love. Big love for Big Rice Street. And I swear it switches your name. It says Rice Street sometimes, and then you get back to the @ name at Big Rice Street. So if I'm switching back and forth, it's StreamYard's fault. Miss Sparks just types out rice emoji in the chat. Love it. Love it. Guys, let's get back to this declaration that seems like an argument. Let's see, 7. Third, to add insult to injury, on September 2nd, 2025, defendant threw a pen at a man outside the Alhambra courthouse in California. The incident happened while she was on a lunch break during the trial. The incident caused another individual to get pushed and injured. It was also completely unlawful and disrespectful for defendant to injure others during the trial. And again, this is the same verbiage, like word for word as included. So this is the argument included above. But now he's representing this as something he has firsthand knowledge of, personal knowledge of. And it's others, plural. Who's the other? Who's the other person that was actually injured? Where is this individual? You're personally aware of this individual, but you're saying above you needed time to talk to jurors about this incident. You know, attach a declaration from these individuals. It was also completely unlawful and disrespectful for defendant to injure others during the trial on the Alhambra courthouse property, which she did on September 2nd, 2025. And it's word for word, you guys. Additional time is needed to determine if defendant's actions of throwing a pen at a man outside the Alhambra courthouse were witnessed by the jury. Plaintiff requests additional time to investigate this further. Jurors would be intimidated if they had viewed this type of conduct. You're conceding again that you don't have any reasonable belief that the jurors were in fact intimidated, because you're speculating that if something had happened a different way, then a certain outcome that the jurors would feel intimidated would be in play. But it's not even on the table, and you're conceding that. So this is supposed to be an argument for a new trial where you're explaining what reason is there, what basis do you have that we shouldn't have confidence in the jury's verdict. And you're pointing at all these things and how the jury is not aware of the things that could, if you argued it differently, maybe get you there. But you just keep conceding. And again, this is the number 8's repeating too, right? This is not defendant's first time. Motion 403. 403. California uses something different than 403. A lot of states will adopt like the federal like rule 403. Federal is also like waste of time, confusing to the jury, all of that good stuff. Georgia, we know full and well, Georgia follows their code, adopts the federal numbering system. So Rule 403 is the same in Georgia state as it is at the federal level. California uses like 386 or something. I don't remember what it is. We heard it from Lewin during the ASAP Rocky trial. Whatever that is, this feels like 403. This declaration is a recitation of arguments from the motion. It's just repeating the argument twice. That's not how facts that are supposed to support your argument work. 403, spell it out. Spell it out. Aaron, we are in the civil realm today, but I hope you have fun with this one. This is a time. This is a time. In consideration for the reasons set for, okay, we know about the Dre's nightclub thing, the beach club. She feels she's above the law. This is not personal knowledge. This is not what you put in a declaration. Plaintiff should be allowed a fair trial. Again, granting plaintiff a new trial will provide her with the closure that she needs. It's not why we give people second trials. In consideration of the reasons set forth above, I respectfully request that this honorable... So you're making the request in your declaration. This isn't how declarations work. Oh, why are we doing this? So, shout out to everyone. Bowlegs. Bowlegs just entered the chat and I'm just screaming. I'm screaming at my screen. Good to see you. I think in a few seconds you'll understand why I'm screaming. The matters set forth in this declaration are true of my own knowledge, except as to those matters which are stated on information or belief, and as to those matters I believe to be true. I mean, it's your argument. I declare under penalty of perjury under the laws of the state of California and the U.S. that the foregoing is true and correct. And he executes this on October 31st. There you go. Service, cool beans. Guys, on a scale of 1 to 10, rate this motion for a new trial. And let me clear the air. I am not anybody's, like, I'm not a fan. Like, I see people doing stand beef. When the trial was going on, there were so many opinions over on X that seemed to be completely outside of any observance of the trial and the actual litigation, right? But there were a lot of opinions that were just like, go Emani because I hate Cardi, and go Cardi because I'm a Cardi stan. I'm a Cardi stan. And that's not what I do here. Like, I have no interest in... Cardi B is going to have her career, whether she has to do a retrial here or not. I don't think this is going to make a difference, even if somehow, some way, Emani Ellis, the judge, reads this and grants the motion for a new trial. I have nothing against Emani Ellis, although I'm concerned at this point that your attorney's taking you for money. Because this seems like, I wonder how much was billed. Maybe he's doing it as a nice little favor. But oh my gosh, if this is what my attorney produced, I got to get a substitution of counsel. I have to get another attorney because this does not seem like a logical argument for a new trial. Yeah. Kaiser's mama says this lady is 403. Adventure Aaron says this motion was certainly interesting, and those are the most charitable words I can find at this point in time. Yeah, Max says 403 is for wasting the jury's time, not the judge's time. Yes, because it's evidence if it should be presented to the jury or not. So it is applicable to the jury being the recipient, but we're using it here. Like, why are you wasting the judge's time? Oh my gosh, we have a -12, we have a 2, we have a bunch of rolling, we have a -10, 0, we have a 403, very generous, Nem. -2. Guys, usually when we get some negatives and some zeros, there are some others mixed in that are like 5, -325. I don't know. Big Rice Street says, Kat, does MSN have to tell you if they use your X post? I don't know. I think that's like kind of public, right? You're just supposed to embed the... I think it's more of an issue if you take material from X and aren't embedding and linking back to X. I think it's a terms and service for X. Like, X has more power to be on the receiving end of credits than the posting user. It's different if, for example, I post something and my post contains a picture or a video that I took, that would be different. So, but I think the words that are in a post, I don't think that somebody needs to tell me or get my permission to use my tweet. Erin says 0 out of 10. Loner and Amber says she has no case. Guys, we're going to get over to we got a bunch of tacos from Candace. Oh, yeah. What if it's a bench trial? Can 403 come into play? Oh, that's an interesting question. Yeah, Matthew says this was a temper tantrum about a pen. And we're not even getting a declaration from somebody from the others that were supposedly injured by this pen. So, I mean, and then you're conceding that you have no knowledge that the jury knows anything about it. You're asking time to ask them if they have any knowledge of it. But again, that goes back to my other hypothetical, right? Thought exercise, guys. If you were a juror and you were taking part in deliberations for a trial where somebody's being accused of assaulting somebody, and you witness somebody throwing a pen, if there is proof positive, if a juror signs an affidavit saying, yep, I witnessed that, how would that not be favorable to Emani Ellis? It doesn't make sense to me that if jurors secretly knew about this pen throwing, that it unfairly made them render a verdict against Emani Ellis. The logic, it's not there. Like, my synapses refuse to fire. My neurons won't do it. So, oh my gosh. Let's see, you guys. This one's a bit longer because there are a bunch of affidavits, and I think it might be a little bit more complicated to parse out because it's going to make references to orders and timeframes, but we're going to get through it together as a chat. So we're looking at, and this was filed, all right, this was filed on today, 9 in the morning, 9:46. So ex parte application for order, reservice of order to show cause on Ron A. Rosenjonfaza. So seems like we've been trying to serve Jonfaza something, and we need an order from the court. We're making a request to the court because there's an issue. So this is going to be their memorandum of points and authorities and a declaration of Daniel Emani in support. So we're going to also see if this declaration is argumentative or acts as a declaration should. All right, so here's the application. So on October 20th, 2025, the court granted the application of defendant Cardi B, professionally known as Cardi B, for an order directing Ron Jonfaza, counsel for plaintiff Ellis, to show why he should not be sanctioned and or held in contempt for his trial misconduct. Now, if you're just like casually listening to this and we're reading it right out, if we just read straight through the motion with no commentary, then read this, if you weren't tight on the names and knowing the who's who, I can see somebody making a casual mistake thinking that this is filed by the same party that's filing the motion for a new trial. We're talking about opposing counsel engaging in trial misconduct, but this is a role reversal. This is Cardi's attorney saying, no, it's actually Ron Rosen that on October 20th, court's granting an order against Ellis's attorney, Jonfaza, to show cause why he should not be sanctioned or held in contempt. So this is already the court saying, yeah, I want to know more on this. You need to show me otherwise. So while the court's order to show cause bears an October 20th, 2025 filed stamp, it was not provided to the certified electronic service provider, One Legal, and in turn provided to defendant's counsel until 5:08 p.m. on October 27th, 2025. Nevertheless, defendant promptly sought to personally serve Mr. Rosenjonfaza with a copy of the OSC, the order to show cause, and application papers. However, as detailed in the attached memorandum and declaration, Mr. Rosenjonfaza has willfully evaded personal service and has failed to respond to the request he accepts service. Yet he has been served by email, as he previously demanded in writing, and by personal delivery to his office of record and to another address he has used in this litigation. He presumably also was served via the court's electronic filing system. Yeah, I had this question, and they're pointing out that presumably he should have also had service. And what I like about this is, in a way, I would hope that the judge would take it into consideration that this isn't the plaintiff herself's failure to do something. This is her attorney. And so if he's doing something he shouldn't be doing, and then if he's evading service, that looks like a disservice to his client. Because now you're going to go through the motions where you could be facing sanctions. And hopefully something like this, it doesn't seem like this is in relation to Emani Ellis at all. Other than that, it happens to be her attorney that's engaging in these behaviors that we now have to file this application for. So, accordingly, defendant respectfully applies for an order, 1, deeming Mr. Rosenjanfaza served with the court's order to show cause by email. So declare that he's served, as he previously demanded in this action, and by personal delivery to his office of record, both of which have already been done, or alternatively, 2, permitting the service of the court's order to show cause on Mr. Rosenjanfaza by the foregoing methods, and permitting defendant to reserve him by those methods by close of business day on November 8th. So, alternative service. Mr. Rosenjanfaza should not be permitted to dodge the court's order to show cause by evading service of it. So, identification of counsel. They give Janfaza, they give his law office, the address of his law office, his business number for his law firm. Cardi B is represented by Peter Anderson, Eric Lamb, and Daniel Imakuri of Davis Wright Tremaine, and Lisa Moore of Moore Peguino. The contact information for defendant's counsel is listed on the captioned page above. There's no prior applications for similar relief. And then they're just saying that proper notice of this ex parte application as required by the rules of procedure 3.1203 and 1204 has been given to plaintiff's counsel, Mr. Janfaza, by letter sent via email before 10 a.m. on Wednesday, November 5th. So we're going to have a declaration here. So it just seems like they're looking for either declare him served, because there's the electronic thing that if he's still representing Emani Ellis and still active in filing motions, you should be paying attention. You should be getting these notices. So you either got to come in and say, hey, Your Honor, I didn't get that notice. My mistake. Now I note it. Like, what else are you going to say? Because anything else just makes it seem like you're not keeping up with your P's and Q's on behalf of your client and the case that you're still pursuing a new trial for. Or it's going to seem just like a disingenuous excuse. So Big Rice Street says, seeing the word ex parte gives me PTSD. Yeah. It's not, an ex parte isn't like just inherently a nefarious thing, but I think all of that mess and chaos with the 2 ex parte meetings around June 7th and June 10th in the YSL trial are just things that we'll never forget. So, oh my gosh. Snappy Turtle says, Kat, there is more litigation with the attorneys. The judge has reported lawyer to the bar. So do you mean, for clarification, do you mean Janfaza? And do you mean this judge? So like this judge would have personal awareness already because they themselves are the same judge that reported the lawyer to the bar? Oh, man. Please tell me it's the same judge. And Miku says it's the Girardi rule. California is messy. California is messy. And I think in part, California has some bigger players that, can probably afford to litigate. So, in other cases, the craziness might not make it this far along in the process. Oh, gosh. My goodness. Crazy. And Nem says the lawyer replied to the contempt. The judge chose a date for the sanction contempt. He replied to the court with, "Nah, let's discuss the new trial on the date." So there's dual. That's why he already had. You're kidding them. So, flipping back over to the motion for a new trial, I was confused by this. How they just picked a date on their own. Nem, you're saying this hearing date is another matter? This is the show. No. This is supposed to be the tentative show cause hearing date? And just sua sponte, Emani Ellis's attorney decided we're just going to usurp that date. What? I was so confused seeing this here because at first when I started reading it, I thought that this was like an attachment of an order from the judge, and then we jumped to the motion below it, but then it went right into motion. It's all under the motion caption. That's crazy. Why would you do this? This just seems like a way to, even if a judge is like, "I'm not buying your argument. I think your argument is a reach." That's very different than, "You're really trying me right now." And this Oh my gosh. Oh my god, Emani Ellis, if you are paying this attorney, please cut your losses. He I think this attorney is embarrassing his client. And my personal opinion on the trial, based on what was presented, it seems like somebody was going out of their way. It seems like Emani Ellis, in my opinion, was going out of her way to impede on somebody's privacy during, their visit to a medical office. And they took it too far, and then they wanted to make a claim, catch a bag after the fact. That's my read of the case. I would have not found Cardi B liable myself if I was on that jury, based on what I saw through the trial. But at this point, this is a totally different issue. I think what's going on here with this motion is just above and beyond what, call her claims frivolous. I still don't think an attorney should be doing this. Oh my gosh. Yes, Betsy, I'm gonna do it. I think a few people have now recommended, guys, and if you also want to go check out Emily D. Baker, EDB, she did a video on this about a week after the trial concluded. So I've got to go back and find it and look for it myself. I have not seen it. But just for that context, the chat has said that it's, don't go back to the trial days, go like a week after the trial. Oh man. Good morning, FFS. It's been a day. Oh, well, back to this. This is crazy. This is crazy. And imagine if like you didn't have an attorney and you had to respond on your own to this mess. So back to this memorandum here in support of this ex parte application, where we want to say, like, look, service has been effectuated, or we're granting you an alternative means of service that you can try. We've got one. Mr. Janfaza was served with the order to show cause and application by email, and he evaded the multiple attempts to also personally serve him. Speaking of evasion of service, on October 23rd, I mentioned that Tyrone Blackburn's criminal case, because he's charged with attempting to run over a process server and then leaving the scene he didn't want to turn over his driver's license. That was moved. I think he only faces 4 charges now. I think it was originally like 7, but now it's down to 4 after arraignment and everything took place a week later on October 29th. His next date is like months away. So won't be updates on the criminal side of the Tyrone Blackburn criminal case in relation to attempts to evade service to the point where you allegedly hit somebody with your vehicle. You hit the process server with your vehicle. But keep your ears peeled like 2 months from now. We'll look for updates on that. Guys. A. Defendant has complied with the order to show cause's requirement of service by email. So Cardi B respectfully submits this memorandum in support of her application regarding service of the court's October 20th order, directing plaintiff's counsel, Janfaza, to show why he should not be sanctioned and or held in contempt for his trial misconduct. And we're going to get to this declaration that's attached. While the order to show cause bears the date that we went through this, guys, the order was put into place on the 20th, but it wasn't made available to the defense until October 27th. The order to show cause provides for personal service of the order to show cause and defendant's application on Mr. Janfaza, and also electronic service to the email address tillybeverlyhills@yahoo.com, the address he is designated for service of process throughout these proceedings. Well, you're done. That's your service. You designated this. You're like... I wish I could be a fly on the wall. I hope somebody goes to the courtroom. I hope media goes for this messy December 5th hearing that is apparently going to be commandeered by Janfaza and suddenly turn into a motion for a new trial hearing rather than an order to show cause hearing about him. All right, so all of that stuff about the service. They had multiple attempts to personally serve him. So we've got the 9025 Wilshire Boulevard. That's the address of his practice. On October 28th, 2025, personal service was attempted on Janfaza at his office of record and also served via his email. The Wilshire Boulevard address is the same office address that Janfaza has used in his pleadings and filings in this action. So there's no excuse. You're still using it. You're still making representations that that's your address. That's your firm's address. B, it's also listed as his address and email for service in this matter. And C, maintained as his official address of record with the State Bar of California. However, no one was present. All right, so no one was present for those attempts. Personal service attempts at public addresses of record. All right, so woman answers door at another address. Says Janfaza no longer lives there. Let's see, Caitlin Tilley. So they used a public record search, found Caitlin Tilley, who Janfaza represented to be his assistant, and who he insists receive and transmit electronic service of documents on his behalf. Service attempts were also unsuccessful to that address. All these personal service attempts, you guys. What? Okay, I was going to skip these, but let's read this. Personal service attempt at 9025 Wilshire Boulevard. So we're back at Wilshire. They try again. Personal service was again attempted on October 28th at Mr. Rosen Janfaza's purported address for record in this matter. The process server was met by a person claiming to be a magician. Is this real? Oh, and the magician states that the office is his own, that Mr. Rosen Janfaza was not there, and that he only accepts deliveries from Mr. Rosen Janfaza. Oh my goodness. So all right, they've got another attempt here on the 29th. So the next day they try to go back to the same address. Public records checks revealed that Mr. Rosen Janfaza is also affiliated with 9025 Wilshire Boulevard, Suite 200. So they're going over to 304 again. And now they're also going to try Suite 200. So it's a different office, same building, which was found to be occupied by a magician. Service was attempted. What are the odds, right? Is this like a disappearing act? The office was being used as a shipping center, and the three occupants did not know Mr. Rosen Janfaza. Upon returning to Suite 304, building staff stated that Janfaza receives his mail at Suite 304, but has not been a tenant in over 15 years. So now we get to request to accept substitute service. So on October 30th, counsel for defendant emailed Janfaza at the Yahoo address, the Tilly Beverly Hills, asking that he accept personal service of the order to show cause and accompanying documents. Janfaza did not respond. Let's see. Now they try to serve him at scheduled court appearances. Uh-oh. On October 31st, personal service was attempted at courthouse located at 111 North Hill Street, Department 68 in Los Angeles, and at 825 Maple Avenue, Department E in Torrance, California, where Janfaza was scheduled to appear. Janfaza appeared remotely at the North Hill Street hearing and did not appear at the Maple Avenue hearing. All right, so they tried personal service attempt at scheduled court appearances on November 3rd. So they tried to get him at the courthouse at 275 Magnolia and 6230 Silmar, where Mr. Janfaza was scheduled to appear. He appeared remotely. And then personal service attempt at deposition address. So on November 4th, personal service was attempted at 740 North Gary in Pomona, an address provided by Janfaza for his deposition of defendant's expert witness in this matter. Service attempts revealed the building to be unoccupied. So they're showing that they made reasonable effort to try to properly serve Janfaza. And you need to do that before you, hey, court, I need you to help me to effectuate service. You're supposed to try. So they're showing that they tried. 2, we've got good cause exists for an order granting defendant's ex parte application. So we just laid out all of our attempts. An order to show cause for contempt typically requires personal service. However, courts may authorize alternative means of service where personal service is impracticable or defeated by evasion, so long as the method is reasonably calculated to give actual notice and is approved by the court in advance. And I think it's different when you have a layperson. You don't really know their address. They're not updating their address. But the extra layer here is you have an attorney that's still using these addresses in recent filings, like filings that he just filed between the October 20th order from the court and these attempts of service. He's still filed other motions using these same addresses. And now people are saying, well, he hasn't used these addresses. You're an attorney. You have registrations. Like, that's a bit different than just like, well, somebody else moved in with a relative and the last address we knew from them directly was the apartment that they rented 10 years ago. So I don't know. Matt says he's on his way to Vietnam. Chat. Oh my gosh. You guys are great with the context. Miku says he bragged about his office location. Oops. Oh my goodness. So let's see. A lot of authority, you guys. And this is 60 pages. So even though we usually read a lot, we're going to skip through a lot of this. But an ex parte application like this one requires an affirmative factual showing that 1, irreparable harm, 2, immediate danger, or 3, some other statutory basis exists for proceeding without the usual notice or motion schedule. Here, good cause exists because the order to show cause contempt sets a hard service deadline of November 4th as a condition to the court's December 5th hearing. Yeah, the court's December 5th hearing. Oh my gosh. December 5th, guys. But despite being signed on October 20th, the completed order is not available. This is all based on what we saw above. Further, personal service has been impracticable, including because Janfaza's office address of record in this case and with the state bar is false. So, guys, they are just coming out and they are just saying, it could be a mistake, it could be an accident. They're saying the address of record in this case and with the state bar is false. And he has not been located at any of the office and home addresses that public records associate him with. Indeed, the record also establishes that Mr. Rosa Janfaza has evaded personal service, including at all known addresses and those listed in his state bar registration, and has refused to communicate via email, a channel he prescribed for defendant's communication to his office. This declaration, we're going to see if this declaration is a proper declaration, guys. Without prompt court action deeming service complete or authorizing alternative service, the order to show cause will lapse by operation of the court's own order, effectively nullifying the court's order to show cause and rewarding Mr. Rosa Janfaza's evasion. This constitutes irreparable procedural harm to defendant and to the court's enforcement authority. Ex parte relief is therefore necessary to protect the court's authority and prevent Mr. Rosa Janfaza's frustration of judicial process. Let's see. Nor would Mr. Rosen Janfaza be prejudiced by deeming him served with the order to show cause and application. He has actual notice of them, including because they were emailed to him via Miss Tilly as he directed. And on October 27th, 2025, he filed his objection and response to the application. So again, in between that October 20th timeframe, he's still using the material, the addresses. So accordingly, this should be granted. Conclusion, defendant complied with the order to show cause's requirement that she serve the order to show cause and her application on Janfaza by email to Ms. Tilly. And personal service attempts at his office of record revealed that it is not in fact his office, and he has not been a tenant of that building for some 15 years. Further, extraordinary efforts were then undertaken to try to personally serve him, but personal service is both impracticable and being willfully evaded by Mr. Rosen Janfaza. Accordingly, the court should deem the personal service requirement satisfied, or in the alternative, authorize alternative service by another email to Ms. Tilly. I think this is going to be granted. Oh, man. So we have the declaration here. I think we have some communications. Oh, this is the court's order to show cause. Yep, the October 20th order to show cause. This is the electronic proof of service where they emailed it, the order to show cause, to the Tilly address. We have, this is, hey, you know what? Janfaza is filing something on the 27th. He's still using this address up here, this Wilshire Boulevard Suite 304, the Magician Suite address, on a very recent filing that came about after the order to show cause. Let's see. Okay, we've got transcripts, so what do we got in these transcripts, you guys? Just his deposition? He gives the address, maybe? Yeah, I don't know why this is included. We could search and see. Well, this is Exhibit 1. Oh, so this is part, never mind. This is part of this. So they included the whole filing. So that Exhibit 1 is included as part of this thing. That's also, it's an exhibit within exhibit. It's nested exhibits. Yeah, we'll read it. We're going to read it. I just wanted to see, we're not going to read through that whole motion. I'll drop the link for you guys if you want to go through all of the exhibits within the exhibits. All right, so in the chat right now is the order to show cause application. And the next link, the second link in the chat, is the motion for new trial. So yeah, this is not Cardi B's attorneys including this to support their request. This is just part of a motion that they're attaching. We've got an email. All right, that's the one directing. All right, guys. So I think I've got a good gauge on how to make this time efficient. So let's go back up to the end of the request. So we've got the declaration. So let's see if this is an actual declaration. I, Daniel Imacuri, declare as follows. I am an attorney duly admitted to practice before this court. I am an associate at the law firm of Davis Wright Tremaine, attorneys of record for defendant Cardi B. If called as a witness, I could and would competently testify to the facts stated here within. Attached as Exhibit 1 is a true and correct copy of the signed order to show cause. So we're just attesting this is an accurate copy. Attached as Exhibit 2 is a true and accurate copy of Mr. Rosen Janfaza's objection and response to issue of order to show cause, Janfaza. So you guys want to read the order to show cause, the response, his response to the judge. We might chat. I'm always like, we'll keep the stream short, but that sounds like it's worth a read. So we might. While the order to show cause reflects an executed date of October 20th, so we're just saying that, hey, look, me, Daniel, I'm letting you know that we only got this order when it was posted to the online register of actions on October 27th, at which time One Legal immediately transmitted to us. Attached as Exhibit 3 is a true and correct copy of correspondence from One Legal detailing its inability to obtain the signed order to show cause from the court until October 27th, 2025. This is a very different declaration compared to the declaration we saw attached by Janfaza in the motion for a new trial. We're just saying, hey, I'm personally attesting to these being a true and accurate copy, instead of just saying opinions. On October 28th, I caused a public records search to be conducted, which revealed that Mr. Rosen-Janfaza was affiliated with the address 219 South Carson. Attached as Exhibit 4 is an affidavit detailing those service attempts. So I wonder if this is going to be, from a service processor. So they're attaching all of this stuff. On the 29th of October, a public record search reveals that Caitlin Tilley, who Janfaza represented, works for his law office and whose email address he designated to receive electronic service of documents, was affiliated with 346 Hauser Boulevard. Attached as Exhibit 5 is an affidavit detailing those attempts. Same thing. These are all, he's just saying true and accurate copies of these service attempts. All of these things that we talked about above, here's the proof that service was attempted. Let's see. Copy of the email that Janfaza didn't return to. Service attempts, service attempts, service attempts. I gave notice of this ex parte application to plaintiff's counsel, Mr. Rosen-Janfaza, by letter sent via email before 10 a.m. on Wednesday, November 5th. A true and accurate copy is attached as Exhibit 12. And then the declaration under penalty of perjury. Let's get into it, guys. So this is the order to show cause from October 20th regarding, in reference to Ron Rosen-Janfaza's trial misconduct. Let's see, to plaintiff's counsel. Defendant Cardi B, having presented to this court sufficient grounds to initiate a contempt proceeding, you are ordered, this is the court issuing this December 5th date. You, Ron A. Rosen-Janfaza, are ordered to appear on December 5th, 2025 at 10 a.m. in Department T of this court, located at 150 West Commonwealth Avenue. Guys, this is crazy. This is so dumb. Nem, thank you for realizing this, because not only you cured my confusion, but this is crazy. You're telling a judge what their court calendar is going to be. You're interrupting what the judge laid out as the itinerary and said, nope, we're going to do this instead. Please take notice. But okay. Like, usually you'd see, like, at the end of a motion, a request for a hearing. So, back to the order. So, court's ordering Janfaza on this date to show cause why he should not be, one, held in contempt or otherwise sanctioned, or both, for violating this court's July 30th, 2025 order, precluding evidence or reference to purported gang affiliation, and excluding Dr. Alex Avila as a witness. 2, held in contempt or otherwise sanctioned, or both, for violating 2 orders? For violating the court's September 2nd, 2025 order in open court, not to reference in his closing arguments, facts not in evidence. And 3, held in contempt or otherwise sanctioned, or both, for trial misconduct, including in his closing argument, and violations of Code of Civil Procedure Section 177.5 and California Rules of Professional Conduct 3.4F and 8.4D. The court incorporates by reference the attached October 2nd declaration of Peter Anderson, so that's Cardi B's counsel, trial counsel, and exhibits as the affidavit of facts constituting contempt for purposes of Code of Civil Procedure Section 1211A, which identify counts charged. Like, how do you, like, this is laying out the, like, Hansel and Gretel crumbs that, like, you did something once, then you did something again, and now you've got to answer for it. Now you've got to answer. It is further ordered that this order to show cause, together with the application and its memorandum of points and authorities and the declaration of Peter Anderson, and that declaration's exhibits shall be served on Ron Rosen Jonfaza by personal service and by email to the Tilly Beverly Hills email no later than the 4th. Proof of such service shall be filed at least 26 court days prior to the hearing. So we're about to be approaching that benchmark. I think the 7th was the date, so we're like 2 days out from that. Proof of such service shall be filed, blah, blah, blah. Any opposition papers to the order to show cause shall be filed and served on counsel for to Cardi B by email and first-class mail, and no later than November 17th. Any reply papers to the opposition shall be filed and served on Jonfaza by mail and email no later than the 26th of November. So this court has their calendar laid out, but guess what? On December 5th, we're going to do something. We're going to call an audible. We're going to do something different, even though the court has this nice little timetable laid out. Advisements. These proceedings, to the extent premised on a charge of contempt, are quasi-criminal, and to that extent, that's why he has an attorney. That was weird wording. Can we read that wording again? How he in the conclusion of his motion. Right, the conclusion of his motion. Let's go back over. Where he said he was unable to do something because he's represented by counsel. So in his conclusion, Jonfaza's motion for a new trial, plaintiff's counsel is limited in his ability to provide additional information at this time, as he is represented by counsel for defense counsel's wrongful conduct. Anyway, on a finding of contempt, the court may impose per count penalties under Code of Civil Procedure Section 1218A. Oh man. I don't imagine like the Los Angeles version of Lactal flying in there on this one, but we'll see. We'll see. The service, the next exhibit, the next direct exhibit to this application is the October 27th. So this is Jonfaza's objection and response to the issuance of the order to show cause that was filed on the 20th. Oh boy. Guys, strap in. We're going in for the read. We're going in for the read. Hey, Dietrich. Good to see you. It's been a crazy time in here today. Oh, man. Max, I think this is like the lines could be blurred on what type of contempt he's facing, that he could be held in. So I think that's why they're saying quasi-criminal, because maybe the lines are going to be blurred, because we're seeing that he's got 3 things he's ordered to show cause for why he should not be held in contempt. So I think that's what they mean, civil versus criminal contempt. So I don't know. I guess maybe we'll find out on December 5th if the judge doesn't kindly oblige to the new plan to take the order to show cause off the table and instead hear the arguments for a motion for a new trial. All right, so back to the response from, I'm never going to get his name right. We're going to call him Ron. Ron's response to the judge's order to show cause. So to the honorable court and all parties and their attorneys of record, Cardi B obtained a defense verdict against plaintiff on September 2nd, 2025. Defendant made specific... I can picture this being the way things are worded, because things in the legal world are worded weird sometimes. But is this the normal way to say that the defendant, where there isn't a counterclaim, that a verdict, the jury found the defendant wasn't liable? Because it seems like, of course, in layman's terms, Cardi B was probably seeking a not liable. She didn't want the jury to return a liable verdict. But it's not really her seeking and bringing this process forward for the sake of obtaining a verdict against the plaintiff. So this is weird wording. It's worded to me, unless this is the normal way to do it, as if this is supposed to be some nefarious and unfair thing that Cardi B made the jury do. But I don't know. Defendant made specific statements on September 2nd, 2025 to all of the news stations, that the parties would be walking their separate ways when she left the Alhambra courthouse. Plaintiff agreed to move on with the understanding that the entire case would be put to bed. What does this have to do with the order to show cause from the judge? The issuance of the order to show cause retrial misconduct against plaintiff's counsel. Yeah, that's not Emani Ellis. This is against you. This does not apply to Ron. Okay, Aaron says that's normal wording for civil verdicts. Yeah, I was wondering if it was weird legal space. I don't love it gets bulky. I think that's how it gets really confusing to read and understand how things are going. But guys, thank you, Aaron. That is not just weird wording from Ron. That is weird wording in the civil world. But yeah, so this issuance of the order to show cause against plaintiff's counsel Ron is extreme and inefficient. This is the judge. You're saying that the judge's issuance is extreme and inefficient. I don't know if he's making the connection. I don't know if Ron understands that even though he's talking about Cardi B speaking to the news outlets and how plaintiff also agreed to move on, that has nothing to do with the judge deciding to issue an order to show cause. Contempt would require plaintiff's counsel conduct to be willful, which it was not. Plaintiff's counsel is not a seasoned trial attorney and did not initially attempt to violate. Why would you word it that way? Chat, he says, and did not initially attempt to violate any court orders. Oh, intentionally. My bad. See, this is why we need to cut the streams at like an hour. Plaintiff's counsel apologizes in advance to this honorable court for any errors made during the course of the trial, which lasted from August 25th to September 2nd. Plaintiff's counsel was simply asking questions the best as he could in an effort to zealously advocate for plaintiff. Plaintiff's counsel did not ask questions in an attempt to willfully violate any court orders. Defense counsel goes on in an effort to paint a false picture of plaintiff's counsel by presenting a total of 25 counts. But unfortunately, this is after the judges. Think about the time frame. The judge already issued an order on October 20th. This isn't like this is in response. This is filed on October 27th. This isn't like a response to a request before the judge has made an order. This is a response to the judge in response to the judge's decision. Well, if you're going to complain and mock, well, defense counsel goes on and on. The judge has already agreed with at least a few of the points. But okay. So they list them all out. He wasn't supposed to ask the questions about current gang affiliation. And we know that was something specifically in the order the judge singled out as an order to show cause. So I really wouldn't be characterizing, oh, they went on and on, when you know that the judge has agreed that there's sufficient grounds to initiate a contempt proceeding in relation to those mentions. But okay. All right, so the gang affiliation, this line of questioning was drafted by plaintiff's counsel office manager and asked in error. The office manager that we also can't serve, even though you directed us to serve them. This question was immediately shot down and no further questions were asked in this area. Fair enough. Plaintiff's counsel made a rookie mistake to ask this question. It was not asked to willfully violate any court orders. Count 2. Now, flip it and reverse it. If the verdict had gone the other way and Cardi B was in a position to file a motion for a new trial, this is something that was said in front of the jury. So, not only was this something you weren't supposed to do, but it's something that the opposing party could argue if the verdict wasn't in their favor. Count 2. There were so many trial documents being exchanged that this must have been filed in error. Plaintiff's counsel did not willfully attempt to present an improper joint witness list to the court. Count 3 through count 9. And again, I don't think the judge is asking them to counter on this issue. They didn't find that a sufficient part of it's not in their order. So, it's like we're clearing our name here even though we don't have to because it's not relevant to the basis for the order to show cause hearing. Count 3 through count 9, defense counsel makes incorrect allegations about questions related to Dr. Avila. Plaintiff's counsel asked questions about Dr. Avila on the first day of trial on August 25th, 2025, which were overruled by this honorable court. Please see Exhibit 1. There did not appear, that's that transcript, I think, that we saw with the blocking. There did not appear to be an issue with asking questions or discussing anything related to Dr. Avila when the court overruled defense counsel objections on the first day of trial. And that's why they attached this Exhibit 1 of the transcript. With it boxed in, did you also treat with different psychologists, including Alex Avila and other psychologists on October 8th, 2022 through July 2nd of 2023? And then Cardi's counsel Anderson says, objection, violation of the order granting the motion in limine. And then it was overruled. The witness answers, can you repeat the question? And then Janfaza asks, did you seek treatment from psychologists, including Alex Avila and other psychologists from October 8th, 2022 through July 2nd of 2023? Anderson says same objections. Court overrules. The witness says correct. Yes. And then Janfaza says, and for that psychological treatment, did Dr. Avila's office agree to treat you on a lien basis? They did. Yes. And then it looks like they move on to other questions. So he's attaching that here, but I don't know if this was all of count 3 through 9. But what exactly was said in this order to show cause on this issue? So held in contempt or otherwise sanctioned for both violating this court's July 30th, 2025 order, precluding evidence or reference to purported gang affiliation and excluding Dr. Alex Avila as a witness. I believe that this was probably just in reference to what this motion in limine granted. This order granted. So they're probably writing that this order granted both requests. Let's see, count 10 through count 25. Plaintiff's counsel presented a closing argument as best he could. This was a televised case with high emotions and very little sleep. Defense counsel argues that plaintiff's counsel, hold on, guys. Gotta run this one back. Oh, man. Plaintiff's counsel presented a closing argument as best he could. This was a televised case with high emotions and very little sleep. Defense counsel argues that plaintiff's counsel's closing argument was presented in an effort to willfully present facts outside of the evidence. Plaintiff's counsel did not willfully intend to present any facts outside the evidence. Any such statements were errors. It is evident that defense counsel Peter Anderson has something personal against plaintiff's counsel. Plaintiff's counsel has lots of respect for this honorable court. Is that why you just command that we're going to take over a hearing? The court could have said, hey, we'll address that on the same day. But usually the court decides what to do with their calendar. I don't know. I don't know if this really flies with the little bit that we've read tonight. That plaintiff's counsel has lots of respect for this honorable court and has expressed that in this case and other cases. Plaintiff's counsel took this case on from another law firm for the sole reason of giving the plaintiff an opportunity to be heard. Plaintiff's counsel has already lost thousands of dollars in that pursuit, even though he is struggling financially. Oh, so is this continuing? Is this effort? I mean, he's got to fight this order to show cause because it's about him. But as far as the motion for a new trial, is he still incurring costs for doing that? Is this something that he's doing out of the goodness of his heart? This motion for a new trial? Responding to an order to show cause is on him. Oh my God, the chat with the context again. Shout out to the chat. Matt says Ron was admitted to the bar in 2004. Come on now, counsel. This rookie intentional stuff is ... Yeah. Yeah. And you know what? That makes sense because when he His the address that he used, he was a tenant there 15 years ago for his law practice. Plaintiff counsel's law license is the most important thing to him. Well, right now you should be arguing that it's your ethics, your duty to the court, your client, which he would never sacrifice for any reason. Plaintiff's counsel previously proceeded to trial in approximately 10 different cases in his career as an attorney. Plaintiff's counsel also served as co-counsel in several cases in his career. Plaintiff counsel's future career path is to be a judge. No. Oh man. He's speaking it into existence though. I'll give him props for that. He's declaring his future career path is to be a judge. He's not, I don't want to be a judge. I'm going to pursue a career as a judge. I'm working to become a judge. He's just saying, plaintiff counsel, my future career path is to be a judge. It's in stone. It's already, there's no way to get me off track in an effort to help people by administering justice. Defense counsel, and that's even more of the reason you should be doing all of the things that you're being asked to show cause for not doing. Defense counsel threatened plaintiff's counsel several times during the pendency of this is just like a random in the middle of nowhere sidebar about my future career. And then we go back to defense counsel threatened plaintiff's counsel several times during the pendency of this case, as well as the course of the trial, that he would report him to the State Bar of California. Defense counsel violated California rules of professional responsibility, Rule 3.10. One such instance was in writing when he wrote plaintiff's counsel a letter on August 4th, 2025, making that threat. So please see Exhibit 2. There is no question that defense counsel reported him. At this time, plaintiff's counsel wants to move on and does not want to be judged twice. So are you trying to fight an order to show cause because somebody already reported you? Because this is speaking out of both sides of your mouth, because on one hand it's like I've already been, it's almost like he's trying to take the role of someone who's taking accountability. I've already been reported, I've been admonished, I've done the work, this other pathway I had to be accountable over here, and I please ask for your grace and not making me go through those motions twice. I've learned my lesson. It's like he's trying to convey that without actually taking accountability, because he's saying this is malicious. He's already reported me. Let's read the Exhibit 2. Oh my God, is it not in here? Okay, wait, keep going, keep going. All right, so this is from, it's got the letterhead of Cardi's attorneys, the law firm. Dear Mr. Rosen Janfaza, I write in response to the voicemail message you left for me at 8:47 a.m. today. So you can respond in these matters. So back on August 4th, he had no problem responding quickly. First, as a general matter, I reiterate that as stated in my August 2nd, 2025 letter to you, and for the reasons stated in that letter, all communications between our office must be in writing, must be in writing. Uh-oh. Do not attempt to call me or any of that's shady. You gotta do it in writing. This is coming from Cardi B's attorneys to Janfaza. Gotta be in writing. Do not attempt to call me or any of my colleagues, and instead confine your communications to email. Second, I write specifically with respect to one aspect of your voicemail message this morning, namely your threat to hold a press conference about this lawsuit and upcoming trial. California Rule of Professional Responsibility 3.6 bars lawyers from making extrajudicial statements that the lawyer knows or reasonably should know will be disseminated by means of public communications, with a substantial likelihood of materially prejudicing a jury pool and jury trial. Obviously, your threat to call a press conference about this case a week or less before trial is within that rule and prohibited. Since you also state that you have received inquiries from the press, I note that the same prohibition applies to you talking to the press. We reserve, and is this why he's making such an effort? Oh, how did he word it? Cardi talked to all the attorneys, all the news. I think that was in the response to the order to show cause. So we'll finish this, then we'll go up to that. Since you also state that you have received inquiries from the press, I note that the same prohibition applies to you talking to the press. We reserve all rights, claims, and remedies, also including defamation, as to any statements you may make to the press or others, and the right to advise the court of your threatened press conference. Um, well, and we've got the other attorneys for Cardi B. At least Lisa is. I don't know about Lamb. CC'd here as well. This looks like the same exhibit, just forwarding the correspondence. And this is going to the Tilly Beverly Hills at Yahoo. And there you go. So let's go back up. But yeah, so apparently there's this, if we take that email at face value, we had a threat to, on the eve of trial, I'm going to call a press conference. Not just I happen to speak to somebody. I'm purposely going to call a press conference in relation to whatever it is we're discussing right now that seems like maybe you weren't getting something that you wanted. But in this opposition, we're claiming to be a rookie, but we're also making an issue. So this is Janfaza now in his objection to the order to show cause. Defendant Cardi B made specific statements on September 2nd, after the trial was done, after the jury returned their verdict, to all of the news stations that the parties would be walking their separate ways. So, oh man, just hypersensitive. Where were we? Oh my God, does he make another declaration that repeats everything in the filing? That's why I can't find where I was. We just got done reading these things, that the license is important, but defense counsel threatens me. And to show that reference, we refer to an exhibit where in that contemporaneous messaging, defense counsel is accusing you of threatening them. So I'm not sure that's really that helpful. And then you just say, at this time, plaintiff's counsel wants to move on and does not want to be judged twice. So you're not denying that you made a threat over that call, over that phone call. You're just saying you want to move on. This is crazy. Oh my God. Preparing a formal opposition to an order to show cause will require plaintiff's counsel to spend thousands of dollars, which he cannot afford at this time. Well, then you shouldn't have done these things. Numerous hours will also need to be invested fighting this on a case that should be over. You just filed a motion for a new trial 4 days after this. The Honorable Judge Fusselman presided over this entire trial. That's who you're... is that not who you're addressing here? It would appear that this honorable court would not find plaintiff's counsel to be in willful violation. It doesn't appear like that. They're ordering you to show cause. You don't just tell the court that's ordering you to show cause that it appears you're not going to find me in willful violation. I'm like, this is a stream. I should change my thumbnail. I should change the title. It's just Kat yelling at her computer monitor while reading motions. This case is giving plaintiff's counsel a significant amount of anxiety. Oh, no. Stop the entire justice system. Close the courts, because nothing should ever move forward. Nothing should happen if somebody feels anxious about it. Plaintiff's counsel respectfully asks this honorable court to give plaintiff's counsel the benefit of the doubt. Well, why are you asking for the benefit of the doubt when you just said that it appears they're not going to find you in willful violation? Plaintiff lost the case and there was no prejudice to defendant. The jury verdict has nothing to do. The jury verdict about Emani Ellis and Cardi B is completely independent from a judge ordering an attorney to show cause for whatever XYZ reasons. The two do not go together. I don't know if I've ever seen this argued. My client lost, So please abandon your order to show cause to me for why I should not be held in contempt. Yeah, Matt says Ron is showing his judicial temperament. Yeah, how are you going to be a judge? This is not a good look for your future career path as a judge. Oh, man. Curious Lace says Ron is what it would be like if Sarah Boone passed the bar. Is she still looking for an attorney? Just the vision just flashed across. Um, all right, so he has anxiety about this. Please stop. And then he says, taking cases to trial is rare and requires attorneys. Well, this is telling on yourself. You expected a settlement. Taking cases to trial is rare and requires attorneys to be willing to do so without the fear of reprimand. You are reinforcing what Cardi B said on September 2nd to all of those news stations. Let it be known that I will fight. I'm not going to lay down if somebody's trying to get money out of me. I work hard for my money. That's editorializing. I don't know her exact words, but that was the sentiments that she expressed to the news stations after jury found her not liable. Taking cases to trial is rare and requires attorneys to be willing to do so without the fear of reprimand. Is he arguing there's going to be a chilling effect if the judge orders a show cause hearing? He's ordering a chilling he's arguing a chilling effect, guys. He said, why they didn't settle, and now you're trying to scare me from having to go to trial again. You had to go to trial because you chose to represent Emani Ellis, who in her initial pleadings requested a jury trial. You didn't expect it to get that far, but it did because Cardi B chose not to offer to settle. This is wild. Plaintiff's counsel will be taking a trial advocacy class. Oh boy. To better understand how to proceed to trial. A plaintiff's counsel is willing to provide this honorable court with proof of completion if that will satisfy the court. Plaintiff's counsel, for whatever reason, I'm so riled up right now that I think it's worse that after all of this, we're suddenly saying we would take the initiative. You mentioned earlier, oh, he already reported me, so we just want to move on. But now you're saying, I will make an effort if you order me to. Maybe you should have reversed that. Maybe instead of complaining and leading with, at this time, I just want to move on. Defense counsel already reported me to the bar, I'm sure of it. Maybe you should have led with, I already took this class because I want to become a better trial lawyer. I want to become a better advocate for my attorney. I want to learn to deal with what trials entail. Rather than saying that, this order to show cause is going to instill fear in attorneys of possible reprimand. And I would take a class if you asked me to. And he's only willing to do it if it will satisfy the court. So you're only doing it to get out of any type of punitive action from the court. You're not doing it for this whole, I have anxiety, I want to be a better trial attorney. Plaintiff's counsel is, thank you guys for, Miku's headphones especially, I think was like, read it. Plaintiff's counsel is already going to be judged by the State Bar of California. Plaintiff's counsel requests that this honorable court not issue an order to show case, but I guess it's cause, in reference to trial misconduct in the spirit of compromise and efficiency. So you want to compromise with the judge and make it efficient. Plaintiff's counsel is limited in his ability to provide additional information at this time as he is represented by counsel. So we saw that line in the motion for a new trial. For this reason and the additional reasons set forth herein, it is requested that this honorable court not set an order to show cause hearing related to plaintiff's counsel. It's already set, though. It was already set. He signed this on the 26th. It was electronically filed on the 27th, but the order was the 20th. So maybe he submitted this before the order actually was electronically transmitted, but they knew on the 20th that it was happening. So yeah, because I even see over here, it's still marked as filed the 20th. And there's a minute order, read the show cause. So they were told, he was already on notice. This was just the formal order was published. So, oh my gosh. Yes, you delivered, Miku's. Yeah. Dear reader normal people, good to see you. If you want to let the chat know you're formerly known as, up to you to make that call. It's supposed to scare lawyers. It's supposed to have a chilling effect on disobeying court's orders. Yeah, that is kind of the point, right? So we shouldn't be crying like, oh, it's going to have a chilling effect. It's supposed to. Yes. Yes. Oh my gosh. Yeah, and he's treating this like a negotiation rather than an order to show cause. Like this really could have been, I'm prepared to whatever argue this or inform the court in greater detail at this hearing that you've set. But in this filing, I want to let you know that these things weren't intentional. Um, I mistakenly read a question and I did stop as soon as I realized I was reading this question about gang affiliation I wasn't supposed to read. It was not intentional. Sarah Boone. It could have been this long. There you go. All right. So there we go. Pink slime. So dear reader, normal people, formerly known as pink slime. So there you go. You guys might remember pink slime. The only not green slime. Yeah, or maybe he should just show cause. And he's doubling down. This is the time. And then guys, there's a declaration attached to this thing that we just read. But look at the structure. This is what we just read. And then we're back to the same thing that we saw with the motion for a new trial, where we attach a declaration that seems, at a glance, just to be a recitation of the arguments we made above. Again, it is evidence that Peter Rose Anderson has something personal against me. I have a lot of respect for this honorable court. I mean, we're just repeating what was. This isn't how declarations are supposed to work. The Control C, Control P, or Command if we're using an Apple device, right? For Apple users, it's like Command instead of Control is your function key. Guys, what else do we got? So we looked at. So these are the exhibits that he attached. The exhibits within the exhibits. Let's get to the next direct exhibit. Okay, so this is correspondence, this is exhibit 3. So we're back to the application in regards to the effectuation of service. We got the Daniel and McCurry. So this is from Myra Izzo on Tuesday, November 4th, so yesterday at 3:22 p.m. to Daniel, CCing Peter Anderson and Eric Lamb. Subject, re-forward one legal update on case number, presumably this case, and then the automatic reply from one legal. And then it's forwarded, it says they responded to my out of office. Please see attached and below. So this is, I think Kelly is from one legal here, and then Myra is forwarding this along to show that they didn't receive this until the 27th. So remember we saw in the application from Cardi B's team, like, hey, we know your order was signed and put into effect on the 20th, but we didn't actually, it wasn't filed to us through one legal. And one legal even tells us, hey, we had trouble with this, but the stamp, it was filed by printing the document and stamping it with a physical stamp, which is outside of the e-filing process. So the court then sent the document back on 10/27. So this is coming from one legal. And as they promised, they're attaching this documentation. What else do we got? More correspondence with the support. Hey, we're reviewing your order. The court processed the order on the 3rd and provided the electronically received copy of your order to show cause. So yeah, this is just going to why they didn't get the copy of it on the 27th. And then they're circling the receipt date here, electronically received 10/2/2025 at 6:15 p.m. The same thing that we were just looking at over here. They're circling the same thing. Giant signature banner. I don't think this is all that interesting, you guys. It's the exhibits that they promise. This is the effectuation of service then, the attempts at service. All right, so cool. So these attempts at service are from process servers. So you see this person serving, Andy Torres. He's affiliated with Global Network Attorney Service. So this is a process service company. And this is documenting, there's probably going to be several of these. These are third-party process servers. It's not like David, and I'm not accusing David of anything, of saying, or Daniel, oh, I tried and I promise it was a magician that answered the door and he said something about 15 years. This is a third-party person filing their affidavit of service. So unless the court has reason to doubt this individual, which at that point I would assume they'd want to question this individual, it's not an issue of Daniel's credibility. It really hinges on the process servers. So he describes that an older Middle Eastern man came to the door and said Ron had not lived there in a long time. Then subserved the woman who appeared to be his mother. Got an elderly Middle Eastern woman came to the door and said that Ron did not live there. They note that there was a Lexus there. Later on the day, they did not answer the door and they turned off the lights. Another attempt. And we're just going to skim through these, you guys. But again, if you want to read them all the way through, this is just establishing that obviously this third-party process server not only attempted service, but they're documenting, hey, it seems like somebody's home, but they're turning off the lights. So on the 29th of October, 8 p.m., I knocked on the door and an older Middle Eastern man came to the door. He was in his late 60s. I asked for Ron Janfaza, and he said he did not know who that was. I then asked for Caitlin, and he didn't know who she was. All right, next. Is this still from Andy? Okay, this is still from Andy. What date was this? All right, so this is when he left at the Suite 304. I think this is the magician. They left copies of the service packet with Michael G., who was the person in charge on site. So Office 304 has a sign on the wall for Ron Janfaza. He needs to call him before accepting any deliveries. Michael is a magician, runs Gilmore Fagan Community Development Corporation, and fantastic figure magician. Ron only receives his mail here. So shout out to Michael G, the magician. Exhibit 7. We're back, and this is the Suite 200, so the other suite in the same building. 10:29. 2 p.m. Suite 200 has no plaque or name, just the number. I knocked and an Asian woman answered the door. There were 3 Asian people altogether. It seemed as if they were shipping things. Ron was not known to them. I went up to the 3rd floor to take a picture of Suite 304 and noticed they had taken down their information off the wall. So Suite 304 no longer has the information hanging that was apparent at this point in time. Oops. This is process service stuff is hilarious. The janitor was in the hallway and I showed him Ron's picture. And he said that he'd been kicked out about 15 years back for an altercation they had regarding his motor vehicle case. What? Cardi B's attorneys are sparing with the details they included in the actual arguments. They didn't quote this. There are other attorneys that would have said, not only did we attempt service and they took the plaque down, but a janitor comes by and says, no, we had like an altercation about a separate matter years ago and he hasn't been here since. Other attorneys would have quoted all of that in the application document. He said that Ron threw $1,000 at him in the hallway and yelled at him. And since they have cameras, he told the landlord and had him kicked out. but he still received mail over at Suite 304, which might make sense of why they have to call him before. This is hilarious. Oh, man. Oh, Trey Keisha, you entered into a stream. I did not expect this much drama and fanfare and whatever we're going to characterize this with. I hope you enjoy it. Good to see ya. Yeah, it's not his first rodeo, Julie says. Peter Max says dodging service is like peeing your pants. Maybe pieing also. It feels warm and nice, but it does not last. Oh my goodness. Yeah, they could have. K Tally says they must have thought the guy was a bill collector. Yeah, I think that's valid, right? So when someone's turning off their lights, it's not necessary that they're turning off the lights because they have an affiliation and are trying to help somebody evade service. They just presumably don't want to be bothered, is the without further context would be the most logical thing to conclude. Yeah, we're getting the Ron lore. Yeah, so his name has been on the wall for 15 years, but between these attempts at service at Suite 304, once they're aware that someone's looking to serve him, now we have the plaque down. And this process server is noting all of it. So this is actually Gonzalo Ponce. Okay, wait. They're from the same... All right, so they're from the same company, so they're sending a different face. It's the same company and they're sending a different face. Maybe you don't avoid me because I don't look like the same process server that came from yesterday. But Gonzalo's already in tune with what his coworker Andy did. That's gotta be so fun. Imagine like being Andy and Gonzalo and like you get to go back and debrief on like somebody's service evasion attempts. That just seems fun. That seems fun. Anyway, that's crazy that this janitor, they have this dispute about a motor vehicle case and Ron throws $1,000 at him. So I wonder if the janitor hired Ron to represent him and janitor was like, what's going on with it? Well, if you're not going to do something, give me my money back. And Ron was just like throwing the money. But if he's not allowed back in there, seems like the janitor is credible when he says the landlord had him kicked out because there's a reason he can only come get his mail. So Exhibit 8, what do we have now? So this is an email to Caitlin Tilley that we heard about from Peter Anderson, Cardi's attorney, that says, please advise whether Mr. Rosenjanfaza will accept service of the court's OSC, and the application for order to show cause and supporting documents, all of which have been provided to you and him. And if so, please return the dated and signed acceptance of service attached to this email. This would make me quit being someone's assistant. If you put me in this position and like you're an attorney and you're already of record on a case, like, oh, don't put me in the middle of helping you not respond. Exhibit 9. So we have Gonzalo Ponce again. Let's see. We are on Halloween, so October 31st at 8:15 a.m. I arrived at Department 68, so this is one of the courthouse attempts. Took a picture of today's calendar and waited in the hallway. The clerk came out around 8:35 and asked for anyone in the hallway that had a hearing with them to come in. A gentleman in a suit walked in, but there was no sign of Mr. Janfaza. At around 9:10, I walked in and asked the clerk if Mr. Janfaza had checked in for any hearings with them, and he stated that they had just finalized their hearing and that he had appeared via Zoom. I sent my report to my client and left the courthouse. Very detailed. Gonzalo Ponce back again for the other court hearing, I think, right? How's this at the same time? 8:10 and 8:15, so Department 68. Now he's at Department E. And waited for the court to open. There were a few people in the hallway, but none of them was Mr. Janfaza. The clerk came out at 8:30 and asked us to come inside. I took a picture of the calendar and sat down. 4 people went inside the department as I waited outside. At around 9:25, I went inside to ask the clerk if Mr. Janfaza had checked in to appear, and the clerk advised me that the hearing was right at that moment, and he was appearing via Zoom. I was able to glance at the monitor and notice that the person appearing via Zoom was not Mr. Janfaza. I sent my status into the office and left. So this timeline is kind of confusing because these courts are on different streets. I don't know if they're like parallel, if they're all like clustered together, but that's only a few minutes apart. So I have questions on that. Let's see. Next exhibit. This is another courthouse. It's Jorge Silva now. Mr. Rosen appeared via Zoom. Clerk advised him that the hearing had been moved to November 20th. Gonzalo Ponce is back for November 3rd. I asked the assistant clerk that we're back in court if Mr. Rosen had checked in for his hearing at 10 a.m. She said to check with her in about an hour. At 9:45 a.m., I went inside to ask if he checked in, and she advised me that he was appearing via Zoom. So all of these. All right, now we're back into buildings. So Gonzalo Ponce on also Halloween. The front of the building is locked. The main entrance is at the back of the building next to the parking lot. I went inside and noticed that there were individual offices and most of them were empty or dark. I asked one of the tenants if he knew Mr. Ron Rosen and showed him his picture, and he said he was not a tenant. He said that the building had been recently renovated and rented out, but Mr. Rosen was not at this location. All right, and then we have a November 5th email from Myra Izzo to the Tilly Beverly Hills Yahoo email address. It says, importance, hi. Subject, Emani Ellis v. Belcalis Morlenis Almanzar. Letter notice of ex parte. So this is when they sent the notice of the first filing that we read in this document. On behalf of Peter Anderson attached, please find electronic service copy of this notice of the ex parte application. And what do we finish with here? Also by email today. This is the one from this morning. So the legal notice of the ex parte, that they're asking for service to be deemed effectuated on the grounds that Jonfaza has actual notice because he filed an objection response to issuance of the OSC, and then all of their supporting papers. So there we go, you guys. We made it through the Ron lore. We made it through the motion. We made it through the hot mess. Hey, for always, forever, for life. Always good to see ya. Thanks for popping in. Guys, this was going to be a short stream. I was just going to talk about the article. So Kathy Roussan from Law and Crime had shared this article on X. I read it and I was like, oh boy, here we go. When looking for more information, I pulled up this other article that said, although the notice did not contain a formal motion, the lawyer said court papers are forthcoming and that the grounds for overturning the jury's decision will include insufficient evidence to support the verdict in error of law. So I read this. This was about what was said in court before the AOL article from today. This article that I'm highlighting was from a few days ago. When I read this part about an argument for insufficient evidence, I'm like, what? You're the plaintiff with no counterclaim. So what do you mean you have the burden because you're the one making the claim? So to me as a layperson, and maybe this is weird language in the lawyer world, feels weird that a plaintiff without the existence of a counterclaim and a awarded verdict to that counterclaim would be able to make a sufficiency of the evidence argument. That's your fault if you didn't present. like what? So that was confusing. So I went and we pulled the motions, we pulled these filings, and that's how we got to this 2-hour stream, you guys. So I had a great time reading that. I really did not expect that much of a mess. It's a nice break. I've been looking over at the, we've been talking about Terrell Efron and ASAP Rocky. There's 2 civil actions ongoing. One is just the personal injury for the assault and battery. The other is personal injury defamation, where Joe Tacopina as counsel, who spoke to TMZ, failed. He tried to argue an anti-SLAPP motion. Judge said, well, the position that you're in, and because you went to speak to TMZ specifically, I don't think anti-SLAPP applies here. So denied that special motion to strike from Tacopina that was also enjoined by ASAP Rocky. But we've been talking about that a little bit. We've been talking about the Fat Joe case where Tyrone Blackburn is named as a defendant for intentional infliction of emotional distress for his apparent extortionate attempts, along with Terrence Dixon to extract some type of payment out of Fat Joe. That's been a whole time. Now we've got new lawyer drama to add to the roster that I did not. We saw it at trial, right? The dynamic was apparent at trial, but I haven't read any of the arguments on paper, and this is blowing my mind a little. So shout out to Trakeisha when she gets through the replay and makes it back to this point. Always love for Trakeisha. Thank you, Bowlegs, for the kind words. Curious Lay says this has been so fun. I agree, you guys. I've got some stock that I'm cooking. It's going to be lemon chicken orzo soup. It's going to be so good. I thought I would be tending to it like 30 minutes ago already. So I'm going to get out of here. Is there anywhere you guys want to recommend before we jump off? You know, anyone that's live right now, shows that you watched earlier today that you want to give a shout out to. For anyone that's looking for something to do with the rest of their evening or morning if they're watching on replay, because we can shout them out before we close this one out. Yeah, for always. There was a lot in this one. Not gonna lie. Not gonna lie. Oh, and so the anti-slap was denied for ASAP Rocky, Joe Tacopina in the defamation case. But in the personal injury case, separate judge, the same judge that kind of warned Raleigh, like, hey, you might want to cut your losses. He denied the pro hoc vice applications of 3 New York attorneys that Raleigh's new counsel, Ryan Saba, who's a California licensed attorney, wanted to have admitted. So that I don't always see, sometimes when there's like a misrepresentation to the court, you'd expect an application to be denied or if the attorney's not in good standing. But this was actually a different reason. So let's briefly look at that real quick. Let me pull that up. While we're talking about attorneys. Because I was a little surprised to see the denial, but I think that judge is just like, what are we doing? This is burdening the other party at this point. Here we go. Make this bigger. While you guys get your recommendations for other stuff to watch, we'll speed through this. Oh no, Patty B just got here, didn't get notifications. Yeah, vague and ambiguous. I thought it was surprising too. Destin B also says, wow. Kay Tally also, I'm seeing this now, says, what was the outcome with the sandwich being thrown at the officer? Jury deliberated for just over 2 hours. They went home for the day. Court shut down at 5 o'clock, like on the dot, it seems, local time. So tomorrow, when I see an announcement that, well, I'm going to assume that there was a verdict, that we're going to get a verdict tomorrow. If we don't get a verdict tomorrow, this is a misdemeanor trial. There's holdouts in whatever direction. Yeah, this shouldn't be taking that much longer for a misdemeanor. But as soon as I see that people are filing into court for a verdict, I'll pop live and we'll read through the quick tweet thread about what happened with closing arguments. And by the time we're done reading that, I'm sure the verdict will have been read and we'll get to see the update on Twitter. So look for that tomorrow. I would hope. This is supposed to be a 2-day trial. Tomorrow will be the 4th day. 2 hours of deliberations on the clock so far. Maybe they just wanted to sleep on the decision. I don't know. A hung jury would be crazy. A hung jury and then the government deciding to retry would be crazy for a misdemeanor. But we'll have to see. We'll have to see. But this from the Efron v. Myers, the personal injury case. This is the judge's order denying pro hoc vice applications. Listen to the wording. In this very old case, plaintiff alleges that he was shot by defendant on November 6, 2021. Plaintiff's first attorney, Jamal Tucson, filed the complaint on August 10, 2022. Beginning on or about October 26, 2023, plaintiff was represented by a different lawyer, Camille Vasquez. On or about September 10, 2024, Vasquez apparently changed law firms but continued to represent plaintiff. On February 26, 2025, based on the information provided by counsel, this court set the matter for a short 3 to 5 day trial on January 12, 2026. A mandatory settlement conference has been set for December 3rd this year, 2025. In the meantime, on or about August 5th, 2025, plaintiff parted ways with Vasquez and began to represent himself. Then, on September 30th, 2025, attorneys Saba and Owens filed a notice of appearance on behalf of plaintiff. A few days later, Saba filed motions to admit 3 New York attorneys to also represent plaintiff Prohag Viche. And when I got here and I thought about it, this sounds expensive. This sounds expensive. In support of the motions, Saba has filed nearly identical declarations. None of them, however, provides any real information or persuasive argument for that matter as to why plaintiffs' 2 Los Angeles attorneys need to be assisted by 3 attorneys from New York. Saba's declarations also contradictorily state that each of the New York attorneys, quote, has been directing all of the substantive issues in the case, end quote. It is hard for this court to understand how 3 different attorneys, none of whom has been admitted in California, can each be directing a case. Out-of-state attorneys have no presumptive right to appear in California courts, nor does this court rubber stamp Prohag Viche applications, especially ones like these with such minimal and contradictory showings. Finally, plaintiff has cycled through several attorneys, adding 3 more on the eve of the settlement conference, right? Mandatory settlement conference. And the trial is likely to make it difficult and confusing for opposing counsel and the court to be able to focus on the key issues necessary to resolve this case. Accordingly, good cause having been shown, it is ordered that plaintiff's Prohag Viche applications are denied. So that was surprising. I thought the language here was gratuitous. I mean, they're laying out like, look, you keep cycling through these attorneys. I think it's enough at this point. And to do it at this time and then to just copy and paste 3 Prohag Viche motions that contradict when you're applying for 3 different individuals. Like, I think this judge is over it. This is, again, the same judge that said you might want to cut your losses too, really. So let's see. Going backwards, we've got Miku says, I'm going to catch the end of the Miss Abby Zwerner civil case on Lawyer You Know. So, guys, that is the school teacher that was shot. That is a civil suit, a civil case. So if you've been wanting to watch that somewhere, Lawyer You Know has been covering that. Peter Tragos. We've got, let's see. Oh, yes. Miku's also gives the update. And I saw Nick Starro covering this, that Mike Maranchini versus Laura Owens. Mike won today. It was dismissed because Laura didn't show up. So Laura Owens, my knowledge more of Laura Owens is her accusations against The Bachelor, Clayton Echard. She's the one that accused him of, she got pregnant by him through oral sex. And apparently there's other people that she's made similar, very illogical accusations against, and has just been very litigious. She's also been criminally charged, I believe, in the state of Arizona. Maybe, I think Maricopa County, maybe. So there's that. Another L there for Laura Owens announced today. So that was, yeah. But I saw Nick Starro talking about that over on X. I assume he also did a stream. Destin DeVee says Legal Pour was live. So Legal Pour is another to go check out on a replay. And those are the suggestions I see, guys. So we'll round up there. And Miku says, yes, 7 felonies. So not looking good there for Laura Owens. But guys, sometimes that's how long it takes for the cookie to crumble. I mean, the Clayton Echard stuff's been going on for what? Over 3 years? Close to 4? And just because it's in the civil realm, like, I don't, obviously when it's the criminal realm, it's the government against an individual, and there's the literal risk of losing your freedom. You could be put behind bars physically. But in the civil realm, I mean, the accusations, the time it takes, the stress of litigation, the cost of litigation can completely debilitate somebody. So just because it's in the civil realm doesn't mean that it's, oh, well, you'll get over it. It's fine. Let it be water under the bridge. No way. So I think it's nice to see some accountability there. For Always Forever for Life says Laura Owens is nuts. And then the source, guy. So this is Flesh of the Gods. So formerly known as Flesh of the Gods, still kind of doing Flesh of the Gods, but rebranded the channel where he does his trial coverage as The Source. So I'm going to keep trying to say both names just so everybody knows what we're talking about until we've bridged that gap. But he's covering the Devin Michaels in Vegas. And I think, is Devin Michaels the beheaded boyfriend? Where like the head was found in like bleach and pneumonia. And the mom found, it reminds me a little bit of Taylor Schabusiness. A little bit of Taylor to business. So there's another one there, especially if you guys are looking for a trial. I think that started this evening. So it was Pacific Coast at 1 p.m. They started opening statements. So if you guys are looking for a new trial, you could probably get caught up in like an hour or two. So definitely a good recommendation there. And yeah, okay, yep, the beheading one. The head is missing. So lots of, I don't know if we're just hearing about it more, but it seems like there are a lot of beheading cases, which is just not comforting. With that, you guys, I'm going to get out of here. I do got to go make sure I get my dinner made. Tomorrow, again, whenever I see that a jury's gathering, they've got a verdict that they're going to return in the misdemeanor sandwich trial, I'll pop live. We'll speed through the tweets that describe what happened during closing statements. Again, that should be pretty quick because it's just tweet coverage. And then we'll see what the verdict is. I've got some other stuff that's made me say what this week, but we'll get to those things as I have time to do it. You guys all have a good one. Good to see everybody. Thank you so much for hanging out. Bye, guys.